They came to fight back, and they are doing it in court. The Skilled Migrants Alliance, a community-led organization representing over 1.6 million workers, businesses, and families across the United Kingdom, has formally instructed one of Britain's top public law firms, Kingsley Napley LLP, and engaged Sonali Naik KC, one of the country's leading barristers in immigration and public law, to prepare a legal challenge against the UK government's plans to retrospectively double the ILR qualifying period from 5 years to 10. A pre-action protocol letter is being prepared. A judicial review is on the table. And if the government formally changes the rules as it has promised to do this autumn, the fight goes to the High Court. This is not a petition. This is not a protest. This is a legal challenge filed by professionals who are ready to win. The story of the UK ILR court challenge in 2026 is the story of what happens when a government breaks a promise to the people who followed every rule. It is the story of a nurse who left her children behind in the Philippines in 2021 to save lives in the NHS, counting down the days to her 5-year ILR date. It is the story of a software engineer from India who turned down a job in Toronto because the UK promised him a permanent home after 5 years of lawful residence. It is the story of a care worker from Ghana, a teacher from Nigeria, a doctor from Pakistan, all of whom made irreversible life decisions based on a framework that the Home Office is now trying to change around them. On 20th of November 2025, the Home Secretary announced the earned settlement consultation. On 12th of February 2026, that consultation closed with over 130,000 responses received. On the 1st March 2026, the Home Secretary confirmed in an interview with The Times that the changes are going ahead, they will be retrospective, and they will be implemented in autumn 2026. And on 19th of February 2026, the Skilled Migrants Alliance announced publicly that it had instructed top-tier legal counsel to challenge these changes in court. This video covers everything you need to know about the legal challenge, who is behind it, what legal arguments they are making, what the timeline is, what happens next, and what every migrant currently on a path to settlement in the UK should do right now. The first thing you need to understand is who the Skilled Migrants Alliance is and why this organization matters. The Skilled Migrants Alliance is a community-led initiative that was established specifically in response to the government's earned settlement proposals. It describes itself as representing skilled migrants and their families across the UK. According to its own published materials, it advocates on behalf of approximately 1.6 million workers, businesses, and individuals, including people employed in sectors such as healthcare, infrastructure, and technology. These are not illegal migrants. These are not people who overstayed their visas or entered the country unlawfully. These are legally present, tax-paying, rule-following residents of the United Kingdom who were promised a specific pathway to permanent settlement and who built their entire lives around that promise. The Alliance launched a crowd justice fundraising campaign to finance its legal work. By January 2026, it had already hit its initial target of $25,000, raising enough to fund the first phase of legal preparation. Its stated goal is clear. It wants to ensure the government honors what it calls the legitimate expectation of the 5-year ILR route that was given to migrants when they arrived in the UK. The second critical point is understanding who the legal team is and why their involvement is significant. The Skilled Migrants Alliance has not hired a small high street solicitor. It has instructed Kingsley Napley LLP, a leading London-based law firm that specializes in complex immigration and public law litigation. Nicholas Rollison, the head of immigration at Kingsley Napley, is directly involved. This is the same firm that recently led a high-profile legal challenge against the government's private schools' VAT policy, coordinating over 500,000 affected pupils and managing the litigation through all its phases. Alongside Kingsley Napley, the Alliance has instructed Sonali Naik KC, joint head of Garden Court Chambers, and one of the country's foremost barristers in immigration and public law. David Selwood of Garden Court is also involved in the legal team. Sonali Naik KC is already well known to the Home Office. Her involvement sends an unambiguous signal that this challenge is serious, well-resourced, and legally sophisticated. This is not a group of angry migrants making noise. This is a precisely assembled legal team with a clear strategy working to a defined timeline that is triggered by the government's formal announcement of the final rules. The third point covers the core legal arguments that the challenge is expected to be built around. The primary legal argument is the doctrine of legitimate expectation. This is a well-established principle of English public law that says where a public body makes a clear, unambiguous promise or representation to a person, and that person relies on that promise to their detriment, the public body cannot simply withdraw that promise without proper justification. The argument, in plain terms, is this. When migrants came to the UK on skilled worker visas, on family visas, and on other qualifying routes, the immigration rules in force at the time of entry explicitly promised them a pathway to indefinite leave to remain after 5 continuous years of lawful residence. They relied on that promise. They signed rental agreements. They enrolled their children in schools. They declined job offers abroad. They made long-term financial commitments. They are now being told the promise is being taken away and replaced with a 10-year minimum, or in some cases, 15, 20, or 30 years. The legal team is expected to argue that this retrospective application of the new rules violates the legitimate expectation that was created when those migrants entered the UK. The second legal argument relates to Article 8 of the European Convention on Human Rights, which protects the right to private and family life. The Alliance is expected to argue that applying the new rules retrospectively to people who have already built private and family lives in the UK on the basis of a settled legal framework constitutes an unjustified interference with those rights. A recent court ruling in the case of R on the application of AM versus Secretary of State for the Home Department established that the government must consider the cumulative contribution and family stability of workers when making changes to their immigration status, effectively creating precedent for a judicial shield against retroactive changes that destabilize established lives. The fourth point covers the government's position because it is important to understand what the other side is arguing. The Home Secretary, Shabana Mahmood, confirmed in her first March 2026 interview with The Times that the changes are going ahead in autumn 2026 and will apply to people already in the UK who have not yet secured settled status. In a speech at the Institute for Public Policy Research on 5 March 2026, she reaffirmed this position publicly. The government's stated justification for the changes is twofold. First, it argues that settlement must be earned rather than assumed as a default after a fixed period of years. Second, it argues that the scale of projected ILR grants, estimated by the Migration Observatory at the University of Oxford at 1.6 million between 2026 and 2030 under the existing rules, creates a fiscal pressure through the social housing, welfare, and public benefit entitlements that ILR automatically unlocks. The government has also argued that the new system is fairer because it provides a tiered framework that rewards contribution, with high earners and those in strategically important sectors able to potentially qualify in as few as 6 years, while others face longer periods. However, immigration specialists and the legal challenge team have pointed out that the government has published no concrete details about how these tiered reductions will actually work in practice. What counts as high contribution, what the income thresholds will be, or whether any transitional arrangements will be provided for people who have already been in the UK for several years under the existing framework. The fifth point concerns the parliamentary dimension of this fight, because the legal challenge is not operating in isolation. It is part of a broader political and public pressure campaign. 2 petitions calling on the government to retain the 5-year ILR route have together gathered over 340,000 signatures. A Westminster Hall debate on the issue was held on 2 February 2026, introduced by Tony Vaughan MP. The Home Affairs Select Committee has been conducting a formal inquiry into the earned settlement proposals and heard evidence from Professor Alan Manning, a former chair of the Migration Advisory Committee, from Dr. Madeline Sumption, director of the Migration Observatory at Oxford, and from Nicholas Rollison of Kingsley Napley himself. In that evidence session, Professor Manning raised serious concerns about whether the proposed criteria for reducing the 10-year period are actually controllable by the migrants affected, noting that many of the criteria relate to things people cannot simply choose to do. Dr. Sumption warned that the retrospective application risks significant harm to families and children who are depending on their parents reaching settlement within a specific time frame, including young adults in their 20s, who are still classified as dependents and cannot lead independent lives until the main applicant secures ILR. The Institute for Public Policy Research published a separate critique of the reforms in February 2026, and Garden Court Chambers published its own analysis through Adrian Berry criticizing both the legal basis and the policy rationale for the retrospective element of the proposals. The sixth point covers the current legal status of the 10-year ILR rule and what it means for applicants right now. This is the single most important practical point in this entire video. As of the date of this video, the 10-year qualifying period has not been formally incorporated into the immigration rules. It remains a proposal. The existing 5-year route is still the law. The Home Office consultation closed on 12th of February 2026, and the government is reviewing responses. The Home Secretary has signaled that formal changes to the immigration rules will come in autumn 2026. That means there is a window, and that window may be closing. Immigration law specialists at Field Seymour Parks, Davidson Morris, Advantage Solicitors, and many other firms have all issued the same urgent advice. If you are approaching 5 years of continuous lawful residence in the UK right now, you need to calculate your exact eligibility date immediately. You need to speak to a qualified immigration solicitor this week, not next month. If you are eligible to apply for ILR under the existing rules before the autumn 2026 rule changes take effect, applying now may protect you entirely from the new regime. Once the immigration rules are formally amended, there is no guarantee that transitional arrangements will apply to your specific circumstances, even if the government has hinted that borderline cases might be considered. The seventh point covers the Skill Migrants Alliance's legal strategy step by step, and what happens depending on how the government responds. The Alliance has made clear that its legal strategy is adaptive but firm. If the government announces that the retrospective changes will not proceed, the case does not proceed. The Alliance would declare victory and continue to advocate for long-term stability and clarity in the immigration system. However, if the government proceeds as announced with retrospective changes incorporated into the immigration rules in autumn 2026, the Alliance's legal strategy kicks into action in 2 phases. The first phase is the pre-action protocol letter. This is a formal legal letter addressed to the Home Office requiring it to justify its decision and providing it with an opportunity to reverse course before court proceedings are issued. The pre-action protocol is a standard legal step before judicial review and is designed to encourage resolution without litigation. In many previous challenges against the Home Office, the department has changed its position at this stage, either agreeing to consider individual cases differently or making policy modifications to avoid litigation. The second phase, if the pre-action protocol letter is not resolved satisfactorily, is a formal application for judicial review in the High Court. At this stage, the Alliance would seek an injunction to stop the retrospective rules from taking effect, while the court considers the lawfulness of the government's decision. An injunction, if granted, would freeze the implementation of the new rules for affected applicants while the case proceeds through the courts. Judicial reviews in immigration cases can take many months and sometimes years to resolve fully, meaning that even if the court ultimately rules against the migrants, the litigation itself provides a period of protection during which the existing 5-year rules may continue to apply to those covered by the challenge. The eighth and final substantive point is what every migrant currently in the UK on a path to settlement should do right now based on everything covered in this video. The single most important action is to contact a regulated UK immigration solicitor immediately and ask them to calculate your exact ILR eligibility date based on your specific visa history. If you are within touching distance of 5 continuous years of qualifying lawful residence, make your application as soon as you are eligible. Do not wait. Applying under the current rules before they change is the clearest way to protect yourself. Second, if you support the legal challenge being mounted by the Skill Migrants Alliance, you can contribute to the Crowd Justice campaign and follow their updates. The more resources the Alliance has, the stronger and more sustained the legal challenge can be. Third, contact your local MP. The petition process and Westminster Hall debate have shown that political pressure matters in this campaign. The more MPs hear directly from constituents who are affected, the greater the chance of transitional arrangements or policy modification. Fourth, update your UKVI e-visa account immediately if you have renewed your passport and have not already linked your new passport to your digital immigration status. This is a separate but urgent issue that has already caused people to be denied boarding under the new pre-travel digital check system that came into force on 25 February 2026. Fifth, if you have any doubt about whether your salary or visa status is compliant with the new skilled worker pay period rules that came into effect on 8 of April 2026, speak to your employer and your HR team now. Non-compliance with those rules can put your ability to extend your visa at risk and therefore your entire qualifying period toward settlement. The legal challenge filed against the UK government's ILR changes is one of the most significant immigration law developments in Britain in a generation. It pits the doctrine of legitimate expectation against the government's assertion of sovereign authority over immigration policy. It pits the private and family lives of over 1 million lawful residents against a fiscal calculation about welfare costs. And it will ultimately be decided not by politicians, not by petitions, and not by public opinion, but by the courts. The Skill Migrants Alliance has assembled the right team. It has the funding, the legal strategy, and the resolve. But the outcome remains uncertain because no judicial review case is ever certain, and the government has enormous resources of its own to defend its decisions. What is certain is this: every migrant currently in the UK who has not yet secured ILR has a decision to make right now. Sit and wait. Or act now while the existing rules still apply to your case. The window is open. Autumn 2026 is approaching. The courts may yet protect you, but the most reliable protection remains an ILR application filed and approved under the rules that have always applied to you. Do not leave that to chance. Share this video with every person in your network who is on a UK visa and who needs to know exactly where this stands right now. Leave your questions in the comments below. Subscribe to this channel for every update as this legal challenge develops and as the immigration rules continue to evolve through 2026 and beyond.